Reckless endangerment in Seattle or Washington State. What is it? What if you get charged with it? What do you do about it? Well, if you're watching this video and you want information about reckless endangerment or you need to defend yourself from reckless endangerment, you've come to the right place. My name is Fryrear, and I am the defender of justice. Defender of justice. Defender of justice. Defender of justice. And I don't normally look like this. I look like this. And that's because I'm a defense attorney. I'm a defense attorney with a law firm in Lynnwood, Washington. We have been defending people charged with crimes for more than 20 years. And I've been putting out these videos for quite a while now to provide information to you or your loved ones about the criminal law. And so if you find this useful, you can always like this video, you can subscribe to our channel, and please stay to the end because I'm going to share a lot of important information. So in this video, I'm going to talk about three things. What is reckless endangerment? Two, what are some common situations that we see in our practice where people get charged with reckless endangerment? And third, and most importantly, so stay to the end, how we can best defend and what type of stuff you can do to help yourself if you find yourself charged with reckless endangerment. So number one, what is reckless endangerment? Reckless endangerment is a law in Washington State that says if you recklessly engage in conduct not amounting to drive-by shooting that creates a substantial risk of serious physical injury or death, well, that's a mouthful, you're guilty of reckless endangerment. So those terms are all defined by law, and we'll go into that. But basically, reckless endangerment is a gross misdemeanor, which means the maximum penalty is a $5,000 fine and 364 days in jail. And so it's something real serious. So basically, think about it as, hey, the conduct is so scary, according to the police, that someone could have been seriously hurt or killed because of your conduct. Think about it that way. So number two, what are some common situations where we see reckless endangerment? Well, two of them come to mind all the time. One is shooting a gun. You're doing target practice. This happens all the time. You're out in the woods. You shoot a gun, it ricochets off of something, the bullet does, it breaks some glass, someone's mad, now you're charged with reckless endangerment. You're in your apartment, you're in your house, you're cleaning your gun, the gun goes off, goes through a wall, goes into the neighbor's apartment, reckless endangerment. Another situation where it comes up is driving drunk with passengers in the car, okay? You're accused of driving under the influence and you've got a passenger. Well, you were recklessly endangering that passenger, they might say, where you had children in the car. If the prosecutor's really mad, they're going to charge a DUI and multiple counts of reckless endangerment. So the most common situations we see reckless endangerment charged is when a gun goes off on accident or there's target shooting in an area that the police don't like, or a passenger in the car when you're accused of driving under the influence. And those are very serious things. So three, what do we do about it? What can we do about reckless endangerment? Well, in the target shooting situation, there's a bunch of different things we can do. We've actually gotten cases dismissed on something called compromise of a misdemeanor. Let's say a bullet does ricochet and breaks a window. Well, whoever owns that window has a civil cause of action against you, and you can take a look. We have a video about compromise of misdemeanor. Basically, if we compensate them for their window and they sign something, we can ask to get a case dismissed. I remember years ago, I had 4 counts of reckless endangerment, all dismissed on compromise of misdemeanor. Another situation is just to say, look, it wasn't reckless. No one was endangered. We need someone actually endangered. Sometimes officers will cite someone because they imagine it was reckless, but unless they actually have a victim, our position is, reading the statute, that unless someone, you can actually say John Doe is endangered, not just the general public idea, that is not a crime. And that's usually a pretty good defense. Also, if guns are involved, they might have you do a firearm safety class. We need to have you do something to try to improve your situation. On a driving under the influence case, if you have passengers, it's the same type of idea. I mean, was the driving bad or not? Were you just speeding? Is speeding really recklessly endangering someone? Was speeding a substantial risk of injury or death? Yeah, if you crashed your car, maybe, but just because you're under the influence, now it's not a good thing, doesn't mean the risk is substantial of serious physical injury or death. The statute seems to say it's a really, really dangerous thing you need to have done before you're guilty, but that's not necessarily how it's charged. So if you find yourself in this situation, make sure to reach out to an attorney because an attorney will best know how to help, tell you what to do, and try to make sure you're not convicted of this serious offense. So thanks for staying to the end. If you find this helpful, please like the video, please subscribe, and more importantly, if you find yourself in the situation, give our office a call. Again, I'm the owner of the law office of Lance Fryrear. We've been defending people charged with this type of crime for more than 20 years. If you have this situation, you're probably really stressed out, just give us a ring. We'll listen to what happened. We'll let you know if we can help, and we'll be there for you. Thank you.